If you haven't realised, there's a lot of employment law changes coming through this year, which is a significant impact on most businesses, and you need to be prepared for what those changes are. So basically today's seminar is a bit about providing a bit of an overview of what some of those changes are, give you some tips on what you need to look to do to implement in your businesses so that you're prepared for those changes. And some of them are significant in terms of your responsibility as a business owner or HR manager within a business or management of a team. So hopefully, if we've got questions, we're happy to take questions at the end, I think, so that we can answer any of those questions. So thank you for coming out on a nice morning, nice fresh morning, so thank you. So that's me and Karena, so 20 years experience working as a lawyer, so very knowledgeable in the area of law. So shutdown provisions is probably the first one we're going to talk about. So first, this is actually already in place, the 1st of May 2023. This legislation has come into play, and it's regarding temporary shutdown. So if you have a shutdown at Christmas, most of the time it's shutdown at Christmas. Some manufacturing companies do maintenance shutdowns as well. So you need to now make sure so your legislation requires you to provide 28 days notice of the shutdown. So you can't just give them 2 days or a week. You have to give 28 days notice of that proposed shutdown and the duration of that shutdown. Employers will not be permitted to direct or enforce employees to take leave without pay during a temporary shutdown. Now this is a significant change because we've all done it. We all just go, oh well, bad luck, you don't have to leave. Take leave without pay. Suck it up. Should plan better. So that's a significant change. And it's on 78 awards, so it's not across every award, it's on 78 awards, but looking through the list of the awards, it pretty much covers your standard building construction, retail. Most of us would be covered by those changes in the award, but you need to check that it covers your award. Businesses, so that's your 78 awards, and you need to diarise that notice period. So I think, the first thing you do today, go home, make sure you let your staff know 28 days prior. So what do you need to do as a business? So you need to review your current leave policies and your employment contracts, procedures regarding your shutdown provisions, and update those documents as soon as possible. You need to exercise diligence when you're approving your annual leave now. Requests from employees to ensure that they've actually got the leave accrued at the end of the year. So because you don't want to be approving someone 4 weeks now and they're not going to have any holiday at Christmas, because they're going to turn around and go, still pay me. You need to discuss with your HR or your business partners with regard to the future changes, and including factoring in those notice periods and requirements to take paid leave. Update your payroll management systems to make sure that they can account for this in accruing your leave properly. And obviously these recommendations haven't been tested yet, so there's significant changes in how, so it's new law. We haven't actually been able to see what that's like if somebody tests it. I spoke to a client yesterday. They do a 3-week shutdown. We actually notified all of the staff yesterday that we will be approving if anybody requests leave for it and they won't have enough leave. They won't get that leave approved unless we get approval that they will take leave without pay at Christmas. So that's how we're managing it with our business. They're happy to give those people that extra leave without pay, but they're not going to approve leave if it's going to leave them short at Christmas time. So they're sort of not saying, well, bad luck, you can only have Christmas holidays. But they've basically said straight up front, we're happy to give you leave, but if you're not going to have enough for Christmas, you would need to agree in writing that you'll take that time off with leave without pay at Christmas time. So it's really important that you have those discussions with your staff and know what your accruals are. And if you're hiring people at the back end of the year, you need to be mindful about how you manage that as well. Because somebody starts in October, they're not going to have enough leave accrued, and they'll be technically entitled to be paid for that leave.
So you're saying that you can agree
to take the contract
out of this?
So they can take leave without pay, but it has to be agreed in writing.
Okay.
It has to be agreed. So you can't force it.
But that's what you're saying hasn't been tested.
That's what hasn't been tested. Yeah.
Okay.
So it's a bit of a watch and see, but
try not to. Is what I would do until someone else does it first. Try not to.
Jump.
Try and just wait and see.
It's really about managing.
I'm happy to give updates as they come through, but try not to, because if you end up that's not the case, you're going to have to back pay it.
Yeah.
So just be really mindful of that. There will be people that will just take that line and that's how they'll do it, but eventually it will test through. And once we have those couple of test cases through, we'll be able to give some more feedback.
Yeah.
And, yeah.
So do you give them a letter and they have to sign? Just like, okay, I agree.
I would, everything in writing,
everything in writing.
and I understand, blah, blah, blah. So
The
yeah,
terms and
definitely a
conditions.
template.
Because annual leave is always by agreement. So if somebody's requesting to take a 4-week annual leave holiday, it needs to be approved by the employer to give them that leave. And it would be reasonable for you to refuse that leave if they don't have enough leave to cover for the shutdown. So if somebody says, I want to take a 6-week holiday, they've only got 4 weeks holidays, you can reasonably refuse that because they don't have the leave. That's because it's by agreement. Leave is by agreement. So it's going to be a big, like generally the employees want to take the time, right? So it's about managing that situation, but it is a big change. It's a massive change.
So with you said with hiring at the back end of the year, so when that shutdown happens, so they go into negative and then, so you're not paying them just because you're paying them, they go into negative and then they earn that back.
That's right. Yeah, so you're paying it in advance essentially, yeah. So, but it's again,
For some is okay, but for some, like construction and things like that, they shut down for a whole month.
The other option you can do
is it's 4 weeks. And if they've taken 4 weeks or 3 weeks already in the year, which you do want to encourage that well-being, taking leave and things like that. We'll talk about that later, but you just got to be really careful when you're calculating that out. How much is there going to be? Is it only going to be 3 or 4 days? So that's probably okay. Is it going to be 3 weeks? So that's going to be an issue. So just
the other thing you can factor in is skeleton staff. So if you have a skeleton crew running over your Christmas shutdown, it would be those people that have just started that you would say, we can provide you with work during this period because it's skeleton staff. So you can always do that as an option as well, and most businesses have got something that they can get them to do. If they don't have the leave, they can work on the skeleton staff for your shutdown. Any other questions on that one? Respect at work. I'm going to hand over to the lawyer on this one.
I was really excited about this because clearly I only did my homework last night. No, just kidding. On Insight last night, there was a whole documentary about this, and it was it's an ABC program which talks about general topics in the public. So if you ever see it, it's a good one to watch. And they have lawyers and they have people in the industry, and they were talking about respect at work. And what they were saying is it's become a real talking point because now it's being legislated. And what that means is previously if there was issues in the workplace, it would be complaint based. So someone would bring a complaint to you and you would, you're welcome to sit, you're welcome. It would be complaint based, and then you would have a situation where you would implement your policies and procedures in relation to that and then work through it that way. Well, now it's changed. It now has moved away from that, and it talks about a report that was brought in, 55 of the recommendations. There's a lot, and they are moving towards more of an employee swing, which is good in some respects but bad in others, but it talks about this positive duty. So now all employers have to take reasonable proportionate measures to eliminate unlawful sex discrimination, including harassment, victimisation, hostile working environments as much as possible. So previously you would have the policy, the employee would make a complaint and you do it that way. Now the employer has to identify it up front. So what will happen is, with the changes, is we've got to be proactive in preventing sexual harassment rather than be reactive. Last night on the program, which was very fitting, was there was a lawyer on there who was talking about, well, what will happen is if it's a fairly male-dominated space and there's a female, say in construction, which is a common thing, the employer may actually just not hire women into the space, or may not even have women in that space, or remove them out of it because they have to have a positive duty rather than trying to manage the men. They're going to try and manage the woman because they can't stop it. Because I said to that, I was surprised he said that on national TV, but anyway, it was a really interesting conversation around, well, okay, if you're going to make it a positive duty of the employer just won't hire women into the space or won't hire men into the space.
Well, that's exactly what's going to happen.
So,
And even the reverse as well.
But then that's
Exactly.
discrimination as well.
well, that's just, yeah, it is discrimination. Obviously, you've got to be able to prove that they didn't hire you because you're a woman, but you know, it was a really interesting debate around it. It also talked about, you know, different models and policies and what could be implemented. And I think the key takeaway for me was that we just have to be really proactive. Proactive is the key, not reactive. So the bill will make it unlawful to subject a person to a workplace environment that is hostile on the grounds of sex, no sexual banter, offensive jokes, pornographic materials on show. You'll be surprised with the stuff that I see. So,
Or not surprised.
or not see.
That happens in a lot of work.
Or not see. So you might not even be aware of it, but you have to take positive to eliminate it. So it's going to be an interesting space. Their AHRCs, the Australian Human Rights, will now have powers to investigate compliance if they suspect an organisation is not meeting its positive duty. They can actually come in and do a full investigation into your business and work out whether or not you satisfy the positive duty test. So this will sort of rise up a little bit in the unions. We'll see the ability to bring in action on behalf of one or more workers. So we might see some things coming through that way. The changes are an employee can take compassionate leave if they or their spouse or de facto has a miscarriage. So this is further on some of the other changes. A worker who has been sexually harassed can apply to the Fair Work Commission for a stop sexual harassment order to stop the sexual harassment. It used to be a bully order, now it's also a sexual harassment. This is going to be very difficult. Sexual harassment in connection with the person's employment is a valid reason for dismissal. The time frame to lodge a complaint that relates to the Sex Discrimination Act used to be 6 months. It's now 2 years. So even if they leave your organisation, they can still bring it 2 years later. A complaint or victimisation can be considered as a criminal or a civil matter. So there can be criminal parts to it, but also civil penalty to business. Clarifying that harassing a person on the basis of a sex is prohibited under the Sex Discrimination Act. That's actually now been locked down into the definition. It wasn't previously. And protecting more workers by expanding the coverage of the sex discrimination to include members of Parliament, judges and their staff. And we all know about, you know, in Parliament with the issues that stemmed from that. That's where that came from, because they had an exemption to some degree and there were some powers in there that it didn't apply, so now it does. So what we care about is what we need to try and do. So what we need to try and do is review and update all your sexual harassment and discrimination policies. So if you don't have one, I recommend you get one. Review the onboarding procedures to ensure adequate training on sexual harassment and discrimination to all new starters, and I would actually do a revision for all existing staff in relation to what is acceptable, what is not. Deliver training to all employees on preventing and reporting sexual harassment and discrimination in the workplace. Deliver specialised training to managers in relation to responding to sexual harassment, because we see a lot of it where a lot of comments made, oh, you should be flattered, get over it, that's the way I used to do it, it happened in my workplace. Like, you see, that's no longer an excuse, like you no longer can use that. Review the workplace environment to remove any offensive or inappropriate material. You'll be surprised how much stuff is in crib rooms and men's toilets and things like that. So you might want to get someone to do a check around, because you might just think, oh yeah, but you'll be surprised of what things are up on the walls. And display anti-sexual harassment and discrimination posters within the workplace. Really educate your teams about, well, what is sexual harassment, what does it look like, what are your expectations, and what would be the ramifications from that. And you'll need to constantly monitor and audit that. So it no longer will be a set and forget. It will be a situation where you'll be like, okay, when was the last time we did training on this? When was the last time we did that? What is your positive duty? So if you just keep thinking about proactive, not reactive, that will help you going forward. Whoops. Oop, oop, oop. Any questions on that?
Should you also do training on what it isn't? Because I always find people try to.
Yeah, that's a good idea. Yeah, yeah. You could do, what people interpret as sexual harassment, or what it is and what it isn't, and understanding you know, if someone just says, well, there was actually a situation where someone commented on someone's shoes. And I was like, I have really good shoes. Like, I'd love someone to say that to me. But, and a complaint actually went in for sexual harassment. And it was actually someone quite senior in the law fraternity. So it was surprising about, and then we were trying to work out, well, what was actually said? Was it the tone that it was said in? How was it received? Because we always think, well, how I say it doesn't necessarily how the person receives it. So how is it received is really important. Anyway, the complaint ended up being withdrawn, but she had perceived that the comment on her shoes, even though this particular person always is very fashionistic, like loves fashion, was a sexual harassment comment. So it's just educating around, well, actually that's just a really nice compliment versus, you know, a sexual advancement towards you. Whether or not that person had experienced some advancement previously could be a factor, but also whether they thought, oh, if I don't say something now, maybe the next comment will be, oh, you know, I really like it when you wear a short skirt. Do you know what I mean? So maybe they thought that, but in the terms of what we need to identify what is and what isn't. That's a good point.
Just because, I know this is not sexual harassment, but we get a lot of people saying that they've been bullied at work, but they're actually being reprimanded for performance.
Yeah.
And they say, oh, I'm being harassed and bullied. I feel like that this is another
It's similar.
It's similar, but when you're being, that's something
You need to identify the
it's not,
difference.
as long as done in a respectful manner. I think
Yeah, so we
it's
get
important to
in my
stuff.
in my workers' comp space, so I get a lot of bullying harassment claims, like psychological claims are massive. Like, I mean, they have grown maybe 45% in the last 2 years. What that looks like is, well, what is bullying? Bullying is, you know, repetitive behaviour. It's not a one-off, she told me to, you know, get stuffed or whatever. You know, it's not a one-off blow-up. There's actually cases around where, you know, if I turn around and have a bad day and say something inappropriate to you, yeah, okay, I probably shouldn't have said it. But it's a one-off. It's not a constant behaviour in relation to bullying and harassment. So it's just identifying what is bullying, what is harassment, what is of a sexual nature, what isn't. So maybe having that really clearly set out is really important, because education is where you know, they don't learn it. They learn some things at school and they learn some things along life, but everybody's morals and values are different. So then it's just sort of setting the bar as to what is acceptable and what's not.
And I think the difficult thing about the respect at work is it's actually the person who's received it, their perception. It's not what the person's intention was. And that's the really challenging part with the respect at work in terms of being able to manage that in the workplace. So which is why education is really important, and having really detailed inductions, orientations, reorientations of your staff, so you don't just do it once when they start. You have to consistently do that every 12 months at a minimum.
Yeah. And there's rollout programs that you can implement so that you're not constantly having to do it personally, if that makes sense. So, you know, I know Belinda has a series of programs that she runs out, and it might be just they have to do a course online and answer a quiz and understand, and then you mark them off that they've done it. So you don't actually have to physically do it every time. I mean, it's great to have open conversations, but I understand.
Toolbox talks, do it in
And some businesses, you know, you forget about that stuff, right? Because you're busy and you're doing stuff. But I think if you can just constantly have it as part of your training or part of your, whether you do workshops or tools or whatever it is that you do as a team, just constant reminder of that, not in a negative way, in a really positive way, in terms of we're all a team, we all look after each other, this is what we're doing, this is what we believe in, this is our, you know, our mission, what we're about. And that really just brings it in to the fold. It shouldn't be seen as a negative or a positive. It should just be that it's just part of the training. And then when it becomes sort of second nature, it's not such a talking point. But at the moment, it's a hot point. And last night when I was watching Insight, it was talked about in relation to not only things that are happening in work, but what's happening outside of work. So if you're posting things on Facebook, if other employees are talking to other employees of a sexual nature, does that fall back on the employer? Like, so it was actually really quite in depth, and it really got me thinking about this is a lot bigger than what you read on a piece of paper and the way that it's going to be interpreted. So it'll be really interesting to see what cases go through civilly, criminally, and just watch the space. And I'm happy again to give updates as it comes through because these are all new changes. Yeah, cool.
So can I ask one question? Do these rules apply to volunteers as well?
Yeah. Yeah. So they will apply across the board. Anyone pretty much in a work environment. It will contractors, subcontractors, even people that are not your employees. It'll be interesting to see what your obligation is to protect your employees, the duty, against environments and clients, like even for us. So client has a comments to me in a sexual nature. I have to be able to make sure my team know how to respond to that, what to do, who to come to, what that looks like, but also give them the positive duty is that I've given them the training. Because I can't stop what someone's going to say, I don't know, but the positive duty needs to be satisfied. But yeah, it pretty much across the board. I actually think eventually it'll move down into schools and they'll actually move it into some as part of their, how they learn about drug and alcohol education, and they do learn about respect and things like that, but I think they'll move it all the way into schools and then roll it out that way. Yeah. Any other questions? No? Okay.
Okay, so multi-employer bargaining. Does anybody have an enterprise bargaining agreement? Okay, so enterprise bargaining agreement, they've been around for a long time. They sort of went quiet a little bit probably in the last 5 to 6 years, but there's legislation now coming. It's effective from the 1st of June. Multi-employer bargaining will be in place. What that basically means, so an enterprise bargaining agreement is essentially a document that covers off the individual enterprise, their terms and conditions of how they operate with regards to pay, classifications, allowances, all those things. So it's like your own little award for your business. That's probably the best way to summarise it. But it's based on your business. So it's specific to what you do and how you operate, and you've negotiated that with your employees. So it has to be negotiated. There's a consultation process that you have to go through, and your employees have to vote to accept that EBA. You have to have 50% of your employees vote in favour of the EBA, and there's a whole process to go through, which we've just been through, yours was easy. And basically it's governed by the Fair Work Act, and there are advantages and disadvantages to having an enterprise bargaining agreement in place. They probably have gone not as popular in the most recent years because it's essentially a way of increasing wages. If you look at it, from the basics, you've got your award, which provides the minimum terms and conditions of employment for employees in Australia, and then enterprise bargaining agreement was a way of negotiating for productivity improvements, for better terms and conditions of employment for your staff, and essentially, businesses would go backward and forward and go, well, we need you to we'll give you a 4% increase if you guys increase productivity, etc. That's essentially where the history of enterprise bargaining agreements came from. And the modern award still underpins your enterprise bargaining agreement. So if there's something in the EBA that's not silent or not clear, it reverts back to what your award says. So essentially that's what it is. Now, the big change is, it's a good way of incorporating your overtime, your penalty rates, your allowances, and wrapping those in. So some of you might be currently using individual flexibility agreements to negotiate those 5 things, like overtime allowances, annual leave, hours of work, and there's always one that I forget, but you potentially can do that as an individual flexibility agreement as a small business. That's been the easy way to do things. The issue we've got now is multi-employer bargaining. So, what are the changes? So basically the amendment to the Act significantly varies and expands the availability and operation of multi-enterprise bargaining under the Fair Work Act. It will provide, so there's 3 streams for multi-enterprise bargainings to be termed single enterprise employment agreements, supported bargaining agreements, or cooperative workplace agreements. Basically, in broad terms, the Amendment Act will reduce barriers to parties to accessing multi-enterprise agreement bargaining and provide greater power for bargaining representatives, which is your unions. The unions are loving this. Every union delegate I've spoken to in the last 6 months. It's just like, I can't wait for multi-employer bargaining to come into play. They've not had this opportunity in the 25 years that I've worked in HR. It's significant. So basically they can compel employers to negotiate enterprise bargaining for multiple employers. So for example, childcare. I'll use childcare as an example. They can walk into a childcare centre, centre A, B and C and go, we want to do a multi-employer bargaining agreement with the 3 of you. And you're wrapped in then. You don't have a choice. You just have to then start negotiating with the unions and the other 3 businesses or 4 businesses. It's a way for the unions and to essentially drive up wages because they can negotiate with multiple businesses. And it's going to happen, and they're going to target, from what the inside information I've got from the delegates of union representatives that I've dealt with, they're going to target the industries that are well paid. Childcare, aged care and disability, community services, those sorts of things. And retail. Retail's probably the other big one that they'll probably target. And then construction. Construction's definitely going to be one. So if you don't mind using you guys as an example, that's why we updated their EBA before the 1st of June. Because if you have an enterprise bargaining agreement in place with your business, you're exempt from multi-employer bargaining. They can't wrap you into it. So that's probably the reason I would recommend it if you think you're at risk. I've had lots of conversations I'm actually doing another one with a construction client at the moment. We're literally about to vote in the next week because they don't want to get wrapped into a multi-employer bargaining with a whole lot of other businesses because their terms and conditions are different. The other issue is protected industrial action will be permitted to be taken in 2 or 3 multi-enterprise bargaining streams. So protected industrial action will not be permitted in cooperative workplaces. So there's slightly differences in the terms of the wording. I'm actually sort of I think a lot of people are sitting back waiting to see what's going to happen because it is so different to how things have previously been done. And I think I've spoken to a lot of businesses and I spoke to one last week. They're a large retail organisation. They have 500 staff and they're like, I don't know what to, and they pay the award rate of pay. I said, you guys are at risk. I said that you guys are at significant risk because they're going to target you at some point, and they've basically made the decision, we're just going to have to sit and wait because we don't have the bandwidth to be able to implement it at this time. So it's about making those decisions as, what do you do? Do you sit and wait and see what happens? It also depends on how organised the unions are as well. So, and how they're going to target people. So there's that, they've only got so limited resources too, but it'll be I'm actually a little bit worried about how it's going to play out because they essentially unions are always about trying to provide the best service, like the best wages and conditions for their members. So they've got that capacity at this point in time to be able to do it, and it's going to be difficult because you've got multiple businesses trying to negotiate. I'll give you an example of an EBA I did probably about 5 years ago with a company that was with the CFMEU, and it was really, really bad. It was, in terms of the way that they approached the negotiations, they were brutal. It was actually quite intimidating for both the employees, the businesses, and everybody involved in it. Luckily, the organisation had a really good rapport with their staff and had a really good conditions in terms of employment. In the end, the staff sacked the union and said, we don't want you. Because what the union was trying to push was actually worse than what they were actually getting from the actual EBA that the company was proposing. So it's really about making sure you've got good terms and conditions and that you're providing that for your employees. So a union with one member covered by a multi-enterprise agreement will be able to prevent such an agreement, which may apply extensively across numerous employers and thousands of employers, from ever being varied to remove an employer. So you can be locked into it, which is not what you want. So it's very, very contentious. I think if you haven't started looking at it, I definitely would recommend it. So what are the pros and cons of having an enterprise agreement? Improved working conditions, better communication with your staff, reduced conflict, flexibility, streamlined administration. So obviously in terms of wrapping in allowances and those sorts of things, if you're paying, height allowances, you know, all sorts of different, some of the awards allowances, they're as long as your arm in terms of the list, you can streamline some of those, and then you're not going to be captured in the multi-employer bargaining. Cons, it can be an administrative burden. It's not an easy process to go through. It can be reduced competitiveness because typically you're going to have higher wages and conditions. It can be inflexible at times. There can be disruption when you're negotiating. So you have to get your team in. You have to have the consultation with your staff. The best way to do it is to have a committee that are elected by your employees to negotiate the terms and conditions of the EBA, so that you can then have that in place. How to negotiate an EBA. Basically, there's a lot of steps involved in negotiating. You need to initiate the bargaining process, so you need to advise your staff that your employees that you're negotiating. You need to appoint bargaining representatives within the business, so from the management's perspective, and then your employees appoint who they want representing them. And that means you have to, and that's where I find a lot of employers balk at doing an EBA, because you have to give them a letter that talks about their representation rights, which says they can have a representative, which could be a union. And a lot of employers balk at that. Now, we just did one with your business. They didn't elect a union rep. They did it themselves. So it's not really something like if you don't already have unions in your workplace, you're probably not going to get unions by doing it. I've never had that experience. Could happen, but I haven't. Drafting the agreement, so you obviously need nominal expiry date, you need procedures for dispute settlement, flexibility terms, consultation terms. So there's terms that have to be included in the EBA for it to be able to pass the Fair Work Commission test. Then you need to develop the agreement and consult with your employees, so there's a bit of process involved in that. You need to request and hold a vote, so they have to have a vote. You know, typically you just do your old ballot format vote. It's probably the easiest way. It's, you know, tried and tested. And then you have to lodge the agreement, and then it's reviewed by the commission and approved. And, you know, they might come back and say, well, you need to do some changes. The one we did, we had to do 2 changes. It was easy, done. It was probably the easiest one I've ever done, I think, which is good. But you have to pass the boot test. The boot test is the better off overall test. So you will not get an EBA passed if it's worse than the terms of the award. It has to be better than what the award provisions are. And they've got a formula that they use. So when I do the EBAs, I sit down and I work out, well, what's the award rate of pay, what would they have been paid if they were working under the award, overtime penalties, etc., and what are they going to get in comparison if we paid them under the EBA. And that way you've got that data that you then submit once you're lodging it. So it's a bit of a process. It probably takes between 6 weeks to 3 months, depending on how organised you are within a business to do it, because there's time frames that you have to follow as well. You can't just...
Sorry, you know how you said it has to be better off overall test? My issue with that is that awards keep changing.
Yeah.
So how do you future-proof it?
So with the EBAs, you have to provide what increases are going to happen for year 1, 2, 3 and 4. So you're actually saying, we're going to provide, so you know, some of them go, it's 4% increase, year 1, 3% increase, year 2, etc., etc. So it's the test is based on now, but they also look at what you're providing going forward.
But for example, in today's world, we're at 7% CPI, no one would have predicted that.
No.
And the government's trying to push that through. So can you put something in there, like a catch-all clause that you're always better off?
So what I've done previously in those is that you would always compare back to the award. So one of the ones that we've done previously is that we said we would match the increase based on the percentage that the award went up by. So if the awards went up by 4%, we increased by 4%. If the award went up by 7%, we increased by 7%. So you maintain your parity with that. So that's one of the ways we've done it previously when I've done EBAs. The one we've just done a percentage, and it was a decent percentage. Typically it's between 3 and 5% in the past, but yeah, we are sitting at 7%.
Yeah.
Just to give you an idea, the aged care, anyone who's in the aged care industry, 15% pay rise is coming through for aged care industry. Which is probably due, but it's a big jump. But they're sort of essentially doing that to catch up. So they've typically always been underpaid in that industry. And obviously award increases are coming through on the 1st of July this year. I'm be surprised if they're below 4.5%. I'm thinking they're going to be a significant amount. Yeah. So that's negotiating EBAs, it's definitely something you need to sit down and do an assessment on your business, and if it's something you need to be implementing or considering. They do sound a bit daunting, but they're not as bad as they sound. Any other questions? No? Cool.
Also, just with the awards, you really need to know the award, read the award, keep up to date with the awards, because they do change. And so we had a client that hadn't done that and said, but I'm paying in accordance with the award. I said, yeah, from 15 years ago.
Oh, no.
So $200,000 in back pay. 200. So they then had to try and negotiate an agreement, which we did do, because they couldn't afford 200. They're a small business. They couldn't afford $200,000. We ended up saying we could do a payment installment, or we agreed with the ombudsman that the other side would take a lump sum of X dollars, so that it wouldn't follow up on the rest, because it would have been, 10 years before this small business could actually afford it. And that was just down to hadn't kept paid in accordance with the award, but hadn't kept up with the current awards and what was going on. So just be really careful. If you do pay under an award, you don't pay, you always got to check, even if you pay above an award, that you still are paying above an award, not just assume, oh, well, I've got an employment contract, this is what I'm paying. It may actually counteract, and then they can actually go you for that. So just be really careful about that stuff. Oh, pay secrecy. I cannot believe this happened. But anyway, look, employees and future employees now have the right to share or not to share information about their pay. Previously, it was always part of would be a breach of their contract if they disclose confidential information. It can cause conflict in the workplace. What we recommend is that, have a really open and frank conversation about this, because some people don't understand that other people do multiple roles, or they do this, or they're at this level. They just see themselves as the same, but really their positions are different, their descriptions are different, but all they see is dollar value. So one might be paid at $65,000, one might be paid at $75,000, but the $75,000 might be doing more management or reporting or things that they don't actually see. So their employment terms and conditions would need to work out what they're paid, such as their hours of work. Some people don't realise that, okay, they might be $75,000 an hour, but they're part-time, or they're flexible work arrangement. Like, there's lots of things that are very different now. Ask other employees with the same or a different employer about their pay, employment terms and conditions. You'd need to work that out. So employees can't be forced to give this information to another employee if they don't want to. That's the education you need to be giving them. I personally don't want people knowing what I earn. I don't know, it's my own personal private space. And employees can also exercise these rights even after they leave their employment. So that is where it could, if they leave on bad terms, it could get a little bit, oh, well, I was getting paid X, and whether it's true or not could cause an issue. So I think if you have that open transparency kind of discussion about, maybe it's in their reviews or when you hire them, or whether it's in their induction or whatever it is, if you don't talk about it, don't think that people aren't talking about it, because the natural thing is people always, or staff always, want to know what others are getting and always feel sometimes worse off. I don't know why that is. I think that's well, how come they're getting paid that, or why am I getting less? Maybe that when they started work they were paid less, but they're up for a pay increase, but they're not. They don't think like that. They think, well, how come that person's getting more than me? So just be really open about that, because we're not going to be able to hold people to it. Key things that we should all be doing is, it's an interesting market. Employees have always had a bit of a swing on the market, because we need them and we want them and we want good value. So just doing some benchmarking across, and you can do that by calling around anonymously other firms, or have a look on Seek or other jobs that might be going around. Hayes is other firms, agencies. You can sort of work out and benchmark what things are worth. Have a remuneration policy, what that looks like, understand, encourage staff to come to management rather than discuss it with other staff. Encourage them to come to you and say, look, I heard such and such is getting X. Like, you want to have those conversations. You want to keep good, valuable employees, and maybe you are willing to pay a bit more because you don't want to have to recruit and do it again and whatever. So you want happy employees as best as possible. Review the classification structures and the career progression. And I will share this. Oops, I do it every time. So this is our progression chart, and I apologise because I had to do this quickly last night. We have a progression chart which is an expectations framework in our organisation. And what we do is, depending on what you are, so we'll have paralegals, lawyers, senior associates, and partner level. And we say, okay, if you're at a paralegal, you should be doing most of these things. And if you want to progress, you need to be doing these things. And then if you, as you go up, and when we do our reviews, as you can see here, we mark off where they sit in the progression so that they can say, okay, I want to get to, I'm a lawyer and I want to get to a senior lawyer. Okay, I'm only really doing not much of that. So if I want to get to that, what are the things I need to do? That then allows for people professional growth, where they want to be. It provides a framework, not only just in relation to expectations of your business, but also pay expectations and levels and how they get to those levels. So you might have managers or 2 ICs, or you might have people in roles where you think, oh, actually you're a paralegal, but you're below this, you're a secretary, but you're actually doing a bit more paralegal work. Let's talk about what that role looks like. So you've got to kind of have those discussions. I recommend, and the feedback out there from a lot of my advisory clients is this works really well because it opens up the conversation. Where do you want to be? We value you. What things do you want to achieve? Do you need to go do a course? Do you need to go and do training? What things? And they think, oh, okay. And as long as you are genuine in terms of it, then the employee will really work hard to get there, and then you reward on that, whether it's KPI based, whether it's if this team turns over X, or we do this, or we land that account. It creates a momentum in relation to expectation. By not having the conversation in this market will mean you will lose employees, particularly if they're chasing money, and you will lose people because they think the grass is greener on the other side. Sometimes they come back and say, oh, it's not so green. But that's just the way the market sits at the moment. Any questions on the pay secrecy? Okay, so we're going to move into, I'm doing this right? Yeah. Redundancy. I have had to do a few recently. It's a really sad story, but I did a lot during COVID. Clearly, a lot of people, I did a lot of restructures, and we're still seeing it now. As business costs go up, profits down, we're starting to see, so if you own a business or you work in a business, don't be surprised if you start seeing it, because as we go through with the current market, interest rates up, costs up, suppliers costs up, raw materials up, everything's up, there will have to be some cost cutting somewhere. It will have to happen. So with redundancy, you need to consider your obligations under your awards, agreements, contracts, legislations. So you need to look at, okay, what is my obligation in relation to redundancy? Sometimes it sets it out in relation to what you need to do, mediation, consultation, whatever it is, and you need to follow that. You can look at voluntary redundancy. Someone might be, a lot of that voluntary comes that they're planning to get out anyway and they're happy to take that. You might put that out there and see what expressions of interest you get. Notify affected employees and unions where required. And you need to clearly define the reason for the redundancy. I find people just say, sorry, we're making your role redundant. Yes, but then what happens is, I keep putting the wrong one. We don't go through the consultation process and it falls over and we end up in the Fair Work Commission, and although it's a genuine redundancy in terms of structurally we can't afford to keep you, because we haven't consulted correctly, we get slapped by the Fair Work Commission. Consultation is number one. If you're not consulting or you don't know how to consult, please come and talk to me. I'm more than happy to talk to you, or there's a few people in here you can talk to. Failing to consult, generally in the case law and what I see through the commission, is rather the cause of it falling over rather than the actual termination itself. So there's a couple of cases, and I thought I'd just talk to this one. The employee in question was covered by an enterprise agreement. It had consultation obligations of the employer in relation to a major workplace change. Staples management notified its employees of its decision to downsize its operation and make between 10 and 14 warehouse employees redundant. By the following evening, 12 warehouse employees had been made redundant. So they actually didn't have the consultation process. They just said, we're doing this, and implemented it. 4 of those 12 warehouse employees disputed that it was genuine and commenced unfair dismissals against the former employer. So Commissioner Cambridge, who I know very well and is very fair in terms of the way that he operates, said the consultation in respect to the redundancy of the warehouse jobs was hastily and largely tokenistic, so they didn't follow it. Staples management did not engage in a genuine or meaningful consultation with its employees and their representatives, gestures, blah, blah. There were no proper opportunity to discuss it. So when you have, the consultation process is, look, we need to restructure. We don't have any roles that we can see your skill set would fit. What do you think? Let them come back and say, oh, well, I'd be happy to sweep out the stable. I'd be happy to do this. I'll take less pay, whatever. If there's other roles, then potentially it might not be genuine. But normally they'll come back and say, look, I can't see any way around it. That ticks off that consultation space. The time frame was insufficient, so you've got to give them, a bit of time to come back to you. I mean, on average, we give 48 hours to 5 days, depending upon what the situation is. The dismissals were not cases of genuine redundancy due to inadequate consultation process and therefore satisfied the test. So the test is whether it's harsh, unreasonable, and unjust. Not that they were terminated, it was harsh, unreasonable, unjust. It's the way that the consultation process went. The Commissioner Cambridge held that 4 employees had been unfairly dismissed and reinstated them back into their former positions with back pay. So, consultation, put that high on your list for restructure.
So then once they get reinstated, can you go through the process and get rid of them?
Yes. Yes, because you can actually go through the process so long as you follow the process, right? Majority of it would only come from Adrian. The majority of cases I see, I represent, I go through, I had one yesterday, the consultation is where they have failed. So I say to them, please contact me before you do that, and then have a conversation, and then we'll go through it. Once you get the gist of what you need to do, you get better and better at it. Hopefully not doing it all the time, but you will find. But what happens is they go, oh my God, we can't afford this, we're going to do this, and they just make a decision. And we'd all love to make a decision, which is why we need to be forward planning our businesses strategically and thinking about, okay, well, what does it look like? What can we afford? What can't we afford? What is the situation?
And a lot of businesses used to do the whole redundancy just to manage out people who weren't performing. You can't really do that anymore because you have to be able to justify that it's a genuine redundancy and go through. And so particularly where you've got people doing the same jobs, you can't just pick person A and only consult with them. You have to consult with person A and B if they're both doing the same job. You can't just go, well, we don't want person A. You have to then consult, and that's part of the consultation process.
Yeah.
So a quick question in regards to that. We're considering moving our business down the south coast to Sydney at the moment.
Yeah.
And there's some employees that we definitely don't want to bring with us.
Yeah.
So to get around that, we have to do it as a blanket.
Yes.
That's what you're saying.
Consultate, you need to consultate. This is the restructure, this is what we're doing, this is the situation. Give them an opportunity to respond.
And you might even have people who argue that it's a redundancy because of the distance. So I had a client where they moved from Cogra to Ingleburn, and they had staff say, well, I can't move from Cogra because of whatever reason, and they took it went right through to the commission and for hearing, and they got the redundancies because of the distance as well.
Yeah, so you'll have some people that will obviously go, no, actually, that's no longer the role that I signed up for, therefore I want my role redundant. That's why that consultation process is really helpful, because as you sit down and they're like, oh no, I'm not going to Sydney. Oh, you're crazy. I live there, and that's where your opportunity then to work out, okay, what does redundancy look like for them? How many weeks is it? What's it going to cost us? Blah, blah, blah. Then you can really work out the employees that are going and that are not, and then make a decision, like an informed decision. Because you can just assume that certain people will come. But they might say, oh, no, I'm not, I already got another job, I've got to tell you I'm about to resign. And there's lots of things that can happen, right? Yeah.
When you've got two people in the same role, you said the blanket redundancy, it's not like for like though if you've got one that's been serving for 10 years and the other one that's been...
That's right, you still
so you have to bring the 10, like you choose, because they've got...
Because from a cost perspective, you're not going to make the one that's been 10 years.
But also from a knowledge and experience perspective. So you can't do that then? Is that what you're saying?
You should still consult with both.
So you can't justify that person came in only 2 years ago.
Your decision to make that person redundant.
So all you're doing is you have to consult with the team.
Yeah. You can make that decision based on those reasons, but you still have to follow the process.
Follow the process, yeah.
I
I love process. You see process? Not so much process.
I just like to challenge.
Yes. But with redundancy, steps to a genuine redundancy. So this is what you assess the reasons for redundancy and really be honest about it. So there's a downturn, there's changing technology or restructuring. Consider alternatives to the redundancy, like what other roles might be available. You need to actually consider those, because you will be, if you have to give evidence, you will be questioned on that. Or what other things did you consider? Or there's no other roles because we're in this industry, or their skill set is this, we didn't have it. Selection of employees to retrench to be fair and reasonable, not discriminatory. You've got to be really careful about, it's easier to make 2 people redundant than 1, particularly if there's a performance issue. Generally it's rested with a performance, just quickly, performance-based is you've got to go through, give them the opportunity to improve their performance. Normally put them on a PIP, performance improvement plan. There's no longer, I'm going to talk about it anyway, there's no longer like the need to do the 3 warnings and stuff like that, but the way you manage it is sort of consultation as well, so if you start thinking that way. With the discriminatory part of it, I always say it's easier if you're thinking, oh, maybe this role now and that role in a few weeks, you're better off to do it at the same time, because then it doesn't look like it's sort of pinpointing one person, which sometimes people can feel that it is, but being really transparent is important. Identify employees based on selection criteria, qualifications, skills and experience. So this was just another case example. A warehouse manager's position was selected to be made redundant. There was a decline in business, therefore the employer no longer required the job to be performed by anyone because of the changes in the operational requirements. Due to the employer's failure to consult, it was not found as a genuine redundancy. Job was no longer performed by anyone because of the changes in the operational requirements, and there was a downturn in the business, so you could prove that point, and you could prove why you were doing it, but because you didn't consult, then it failed. The employee's position as a financial controller was made redundant. The employer then hired a qualified accountant to a position titled dealership accountant. The duties identified the job advertisement for a new position were identical. Didn't do that. For the person that was made redundant, the employer placed considerable emphasis on the requirement of a tertiary qualification in accounting. However, the job advertisement did not specify the requirement. It was found that it was not a case of genuine redundancy. Termination was found not to be a case of genuine redundancy. The job was performed by somebody else. So you can see how, you can't just sort of, I don't really like you, I'm going to put, best thing to do is wait a little bit. Maybe don't make it, so obvious. But the problem is that if you don't end on good terms and they see a job coming up and they're still looking for a job, they're probably going to go you. So just
What's the best length of time to wait to fill someone in that position?
Minimum 3
3 months.
Oh, that's all right.
maybe 6.
I know, we're good.
Yeah.
3 to 6, but maybe change it, like the way that it is, like the title.
6 months is better, but 3 would be minimum.
Yeah. Things could have changed, like restructure, business might have picked up, like there might have been changes, you might now need that role, but you'd be
Certainly wouldn't do it in the month of, no.
No.
or the next day, so, you know, so, next day.
Same day.
Not really good to do that on Seek. Looking for an accountant. Sorry, you lost your job. It's just not, yeah. So they're just a little. Am I doing this? Yes. So there's a myth around the 3 warnings, and I didn't realise that myth was still out there until I was recently at a networking event. And they're like, "Oh, you need to give 3 warnings." I'm like, "Oh, that's still out there." You don't need to give 3 warnings before terminating for performance issues. The requirements of the Commission for determining unfair dismissals is basically around, have you given them the opportunity? Do they know what their flaws are? Now, if it is a breach of serious misconduct under their contract, that's different. If it is, though, that they're just not performing, you need to identify what that is. And the best way to do it, I think, and as much as people hate it, they do as a performance improvement plan. These are the things that we want. This is the time frame, and monitor it. There's 2 ways it's going to go. They're either going to leave because they're like, I'm not doing that, or they're going to pick themselves up in terms of their performance because they didn't realise they weren't doing things, whether there's extra training that needs to be done, whether there's something that they're missing, whether or not they need a mentor, that sort of thing. Because what they look at if you then terminate is, okay, did you give them an opportunity? And it can't be a 1-day opportunity, FYI. Not even 3 days, it's not gonna work. Which I've had, and I'm like, I think you're in trouble, so we've had to negotiate that out. But in terms of, I would say a reasonable time frame would be at least a month. At least a month, depending on what their KPI requirement is or what they need to get to, how fast they can get there. Obviously, if you say, you need to improve client interaction and there's no clients for the month, well, you can't really say, well, you didn't do it because there was no opportunity to correct it. Just monitor it, say, look, we'll meet weekly or fortnightly and see how you're tracking, and, normally, it'll go one way or the other. So they'll either pick up or they'll leave, or if they don't pick up, then the next one is, okay, well, is this job the right fit for you? What's happening? What's going on? So the test is still the fair, just and reasonable test. Was it fair, just and reasonable? That's how they look at it in the Fair Work Commission. You can show that you've given them the opportunity to improve, that they're not meeting the inherent requirements of the job, then you're probably fairly safe. But I find what happens is you get so frustrated with the person that you just lash out and sack them, and then that's where it all falls apart. Or you do the performance, but you don't help them, and there's no consultation, and it falls over that way. So unfortunately, you do need to put a bit of effort in with the performance plans and sort of work towards them.
If it's a behavioural problem, can we still do the plan?
What do you mean by behavioural problem?
Say culture, like attitude.
Oh, we love culture. So with culture, you need to really set out what the expectation is, what's acceptable, what's not. And then you need to have a meeting with that person about what's going on. So is it a breach of policy? So you can have policies in place around, what is acceptable behaviours. And even in their contracts, it talks about generally, our contracts do, about, what's expected and what's not. So if the behaviour is serious misconduct, so of a sexual nature, violence, stealing, fraud, all of that stuff, that's a different conversation. You still have to consult with them and they still have to reply to it unless you've got proof, but I would still consult and say, look, this is the proof we have. They'll normally admit it, which is interesting. If it is a cultural issue in terms of someone treats someone really poorly, then you need to pull them into, and they still go on a performance improvement plan. If they don't improve their behaviours, so you can't have employees obviously screaming at other employees, then you will have to manage them out. Yeah, does that help?
Yes.
Yeah.
Thank you.
That's okay. So what claims can employees make? I thought I'd just touch on these. So most of you would know there's an unfair dismissal, that they've been unfairly dismissed, whether it's redundancy or not, like there could be reasons, performance based. There's also a general protections claim, so some of you might have seen those. What that is where you've breached a right, so if you terminate on the basis of illness, on the basis of race, on the basis of sex, on the basis of whatever, there's general protections in there and they can be quite hefty. If they can satisfy that test, it is a harder test than the unfair dismissal. Unfair dismissal, you can only get the 6 months. No one ever gets 6 months, FYI, but that's the maximum. In general protections, it's unlimited, so it can be, I had one, it was $150,000 the employee had to pay out. So then there's unlawful termination, where, was it lawful in terms of the way that the person was terminated? Was it an adverse action? Was it elements? So there's different claims that people can bring, or employees can bring. You just got to be mindful in terms of the time frames as well. So once the claim has been lodged in the Fair Work Commission, they've got to do it within 21 days. You have to reply within a certain time frame. I think it's 7.
Yep.
And then it's just really fast, right? Because they get so much time. They get 21 and we only get 7 to reply. But generally you can kind of, which is why if you have everything in writing, it's so much easier because I can just attach it all. And then it gets listed for what they call a conciliation teleconference, and the conciliator will try and negotiate a deal. However, they can't make a decision. They have to just facilitate. If it doesn't facilitate, then it will be set down generally for a hearing, and then there's a whole hearing process in terms of that. It's sometimes you need to think about it commercially, not principle, because it could cost you a significant amount of money to defend it versus if they're asking for 3 weeks pay or 6 weeks pay. So you've got to kind of negotiate that. So that's where we kind of say commercially, we would say, yeah, you could fight it to the end and probably win, but you might end up paying, $25,000 when they're only asking for 5. Like, you've got to weigh it up. Then spoke. Any questions? No.
So there's new changes coming into play with regards to parental leave from the 1st of July this year. So partnered couples will be eligible to claim up to 20 weeks of paid parental leave between them, and single parents can claim up to 20 weeks. And this is for babies born after the 1st of July. There's means testing coming into play as well. So if a family earns over $350,000, then they won't get the paid parental leave. That wasn't in place previously. And they're expanding the rules for fathers and partners to claim paid parental leave as well. And they're making the whole payment flexible. This is probably the bigger change. So allows to claiming the paid leave in blocks of time up until the child is 2. So it can be single days. So from an employer's perspective, it's a bit of an administrative nightmare. Yeah. Because normally at the moment you get paid your money from the government, you pay it for 18 weeks to the employee, and then they take the rest of their 12 months off, but they could say, well, I want to spread it out, and so they can essentially come back to work and get days and stuff. So it's going to be a bit of a nightmare in terms of administration. But that's a big change coming into play on 1 July, and they're removing the requirement to return to work for eligible to receive the payment. So previously they had to actually return to work. I don't know how they actually ever policed it, but that was what they had in play. So there's significant changes with your paid parental leave, and I find with this is most of us don't really care till we've got someone in the business that's going on parental leave, and then you're like, oh crap, what do we do? How do we do this? What's the process?
Yeah.
I don't understand. And everybody goes into a bit of a panic, and the system that they use is a pain in the bum as well. You've got to go through and lodge it all, and it's a bit of a pain for the employee because they've got to go in and lodge it all, and then
It takes a while to
then
come
you've got to
through.
get approval, and we're actually still waiting for someone. Like
Yeah.
it's as a massive delay. So if you have people going on parental leave, paid parental leave at the moment, give them the heads up. They're not going to get the money straight away because we're still waiting for one at the moment, and she was March,
Yeah.
so we still haven't received the payment.
Yeah.
And it's now end of May, Nelly. So and we're checking, and it hasn't come through. So
And it doesn't get passed on until it comes
and you
through.
don't have to, and you as the employer
are not obligated to pay that money to the employee until you receive the money from the government. Because you don't know if they satisfy the requirements, so don't be paying the money up front because you might not get paid the money for some reason. So you need to make sure that's really clear to your employees when they're going off on parental leave, paid parental leave or maternity leave. That make sure they've got enough leave, got enough savings.
Take annual leave.
They can take their look. Generally speaking,
Long
you take
service
your
leave.
annual leave or long service leave at the front end, waiting for that paid parental leave to come through. But set the expectation before they go off and have the baby. Okay.
Who initiates this? The employee?
The employee needs to lodge an application initially. Then you get an application. Then you need to get an email to say, hey, you've got to approve it. So you've got to go into this. I think it's called Proda, the system. You've got to go into Proda and approve that they're an actual employee of your business.
We don't have to do anything as the employer. The employee starts.
The employee starts the process, but they need to start that process. Get them to start the process before they have the
eligibility,
baby. They can start the process prior to actually having the baby, and then once they've had the baby, then they need to provide birth
They get a
certificates.
barcode at the hospital, and then they have to.
Yeah, and then they do the birth. Then they lodge their certificates and whatnot, and then it comes back to the employer to then process.
Oh, it's real. You're joking with barcode.
No, I'm not joking. No. They get a barcode. They have to add it in, and then they need a birth certificate. I only know because we
Don't
had one
drink the
recently.
water in
Yeah.
Coutts.
I do have a question. You know how it changes, we're just talking down about that, does the employee rather have to lodge that they want to work 2 days, or is that just something we do in the background?
I believe that you'll need to confirm what the
hours.
arrangements will be. It's a little bit vague, the information, because it's not quite in place yet. So I did all this research on this last week, and it just basically said that you're going to have this opportunity to do it flexibly, but
They're
it doesn't
bringing
actually
out
provide the
guidelines.
guidelines
They're bringing
on
out
how to do it.
guidelines. Yeah.
So we'll probably get them 30th of June.
Yeah.
I
I was going to say Yeah, exactly.
2 years.
Yes.
But they haven't changed the 12 months.
No, but that would be, so essentially, normally, essentially you can extend your maternity leave to a 2-year period. So an employee can request to have an additional 12 months of maternity leave. So that would be why they've got the 2 years.
Do you know, Belinda, with the parental leave, is it only in line with what their employment contract is? So if they're a part-time, can they only take part-time parental leave, like in a week?
No, it's an amount of money. It's based on whatever the amount of money is.
If they don't work 5 days, if they take 5 days a week in parental leave.
Doesn't matter.
No, that doesn't matter. Don't believe that matters.
Just the amount. Once the amount is done, the amount's done.
Yeah, and the amount is essentially the minimum award rate of pay, 600, whatever it is, 600 or something a week. I think it'll go up in July.
It's about to go up.
It'll go up in July. The amounts will go up as well. And I think this is stage 1 of the changes. I think there's another lot of changes coming through down the track as well.
Sorry, Jill. So if some people are in industries where the work pays maternity leave.
Yep. Paid,
separate. Say the father or partner rather is in an industry where they're not being paid. After their partner, say, gets 6 months maternity leave from their employer, then they stop being the main carer. The father
They could,
or
yes.
partner can actually claim this.
Yes,
After
I believe so. Yeah.
After.
Because say for example, you've got a business where the employer pays parental leave,
that's right.
they're entitled to the paid parental leave and the government entitlement. I think they're entitled to both.
Yeah, you are, just not at the
Yeah,
same time.
just not at the same time. Not at the same
Because
time.
it can't be as
So
things
they
as
will get
profiteering. Yeah.
But this gives an opportunity.
But it is also,
partner
Yes.
yeah,
who does it to take it instead.
Mm.
Because before it had to be the.
yeah, primary care. Yeah, so there's a bit more flexibility with it. So it's significant changes coming into play, and a lot more. And there's always more responsibility on the employer and the employers. Any other questions? Yeah.
So following on from that, so they can't be both off at the same time?
No.
So how do you know?
Who
If you're not going to have both. Yeah.
Social media.
Radio.
I was thinking it just didn't come out my mouth, but good job.
Realistically,
Yeah,
that's the only
you
way.
can see.
Generally speaking, essentially you would expect that they're both going to be off maybe for the first 6 weeks, right? So the husband, the partner, one of the 3, 6 weeks, whatever. My husband was off 2 days, but anyway, righto. But for example, anywhere up to 6 weeks, they might be both at home and they've both taken annual leave. That's fine.
Yeah, that's
not
fine,
an issue.
yeah.
But you wouldn't expect that they would both be off for months at a time together. And it's hard to police if obviously they're not your employee. But most people can't afford it. So.
The other thing is when they do their tax returns, it'll start to spark stuff. They'll start to see, that's how they'll police it, I think. But it'd be interesting to see what happens in that space.
So yeah, it's a little bit of a pain.
It's like on the job keeper and job seeker and things. Now everyone's getting chased. I've got clients and businesses getting chased because they have declared things that were incorrect, and now when they've gone and done their BAS or done their whatever, it's all come back. And so now they owe the government. And some people have been taken off, so say they were getting Centrelink payments, they now have a debt to Centrelink and they have to pay the Centrelink back. So it will eventually trickle back through because the government's trying to recourse the money back to get into surplus. So they will start to pull on it. It's just, originally I think it was a bit frantic. Just put the money out there to survive. We don't know what's going on. And people who thought they were eligible maybe weren't eligible, but there was a lot of businesses that applied for it that weren't actually eligible for it. They'll be chased now. And I'm talking millions. I'm not talking, a couple of $1,000s. They'll go after the big ones. Yeah.
So with regards to your parental leave, I think it's important to make sure you've got a policy around that as well. So what are the requirements for your staff to notify with regards to going on parental leave, paternity leave? How much notice do they need to give? What's the notice requirements for them to come back? It is 4 weeks that they need to provide. I actually had a debate with a client earlier this week, and they're like, they have to give us 3 months notice. I said, no, they don't. They have to give you 4 weeks notice of when they're returning back to work. People can extend that, so they might say, I only want to take 6 months off. They can then come back and give you 4 weeks notice and say, look, I need to extend it by another 6 months. So there's a whole lot of rules around parental leave and how you manage that within your business. So it is important to have a policy within your business so that you can refer people to that when they go off on leave and they understand what the process is. Any other questions? Doesn't have to be about what we talked about. No? Okay.
I've got one.
Sure.
I have a habitual leave taker, as in sick leave taker. He doesn't show, if he works a 5-day week, we're going to have a party. The unfortunate thing is he's actually a good employee when he's there.
Oh, that's usually the case.
So
It's hard.
those when you just suck it up and say, yeah, whatever, or do you try and renegotiate where you're only paying 4 days?
Well,
Yeah, that's
Yes, exactly right.
I would have a conversation, to be honest. I'd sit down and say, look, I've really noticed a pattern that every time the sick leave ticks over, you're taking it, or every week you're taking sick leave. Is there something that we can assist? Like, is there a mental health issue? Is there something going on for that person? Or is it just that they want to work part-time? What does that look like? Normally when they're pulled up on it in a nice way, it either stops or they'll resign.
I would usually, I would agree. I would be pulling them, having the conversation around, are you okay? Is everything okay?
Everything okay, yeah.
You're taking this, there's a pattern.
And if you don't want to have the conversation, then, you can get, I don't know if you have HR or someone that can just sit down and be like, oh, we're having conversations with multiple people, we're checking in on you, we've noticed these patterns, what's happening. So make it more about the patterns and things and the impact on the team. It's not necessarily about, oh, you're taking sick leave. Maybe they are sick. Maybe they're getting treatment or tests that you don't know about, and that's all okay. You can't ask them directly, but you can just check in to see. They'll either share the information or they won't. And generally I find...
They usually do.
They generally do. They normally, yeah.
So a follow-up question.
Yeah.
This person provides doctor certificates from, firstly an online, it was the first one. And then there's the second one was through pharmacies, so it's not actually going and seeing doctors.
Yeah, unfortunately, your pharmacies are acceptable. Unfortunately.
Is there a concern about them being able to perform their requirement of their role?
It's definitely coming in, as in it's affecting.
Yeah, so then you can implement where you can say we we want to get a clearance to make sure from your doctor that you can perform your role.
Yeah, it's on that.
On their
Knowing
slab.
how hard it is to get.
It's interesting because most in the market at the moment, a lot of people are like, oh, you know, we're just putting up with it. And I had one yesterday, and she was putting up with certain things and trying to be really flexible. Anyway, it's bitten her in the bum because she's actually just found out that the person's working for a direct competitor. But anyway, much as you want to be flexible and all of those things, I appreciate that. I think opening up the conversation first, seeing what comes out of that.
And even offering, like, you know, maybe you're better off knowing it's work a 9-day fortnight, and you know he's not going to be there on that day. Like, are those things you can look at implementing within your business?
Or incentivise not taking sick leave.
Yeah, so
Yeah,
you happy
we
to
do
talk
that.
about that?
Yeah,
You know,
happy to talk about
so
things
Coutts
like
do an ADO system, so it's an additional day off. So if anyone that doesn't take a sick leave day in the 3 months, and Shay's, I think, always gets it. Just saying.
She had one yesterday, FYI, to say.
Yeah. So
Sorry, yes.
But so every 3 months we do a review of so if anyone, they have to have been here more than their probation period, and if they haven't taken any sick leave in the 3 months, they get an additional day off. They just have to take it off within the month. For the month following that quarter, and it's not accrued. It doesn't add to their entitlements, and it's actually worked quite well.
Works quite well,
yeah.
Can I ask, if someone's exhausted all of their personal leave and they're a permanent employee, can they take more personal leave continually at leave without pay?
I think the legislation is 2 days, but technically.
Can they repeatedly? So we've got someone that repeatedly takes a lot for their kids.
That's another conversation I think you need to work out.
And requiring is evidence on those. I generally would sit down and say your pattern of taking sick leave or carers leave is above the 10 days that you're allocated each year. We're thinking it's a little bit excessive, and requiring a medical certificate for all occasions. I know they can all get them, they can log online, and it's not hard, but you know, it's a bit of a pain.
The other path is
you can't terminate for, you know, it's very difficult. They have to be off for 3 months.
3 months within 12,
Within
and it doesn't
12
have to be solid. It can be like sporadic.
Yes, you can do that.
You can do it.
It's 3 months.
It's hard.
Yeah.
Most of them don't get to 3. I've had a couple, but some don't get there. The conversation.
You need to manage I generally find if they're taking a lot of excessive sick leave, look at the performance and start managing the performance issues.
Because what's happening is that they just say, oh, I'm just taking unpaid leave, doesn't affect the business, right? That's how their mindset is. But they don't understand that it actually puts impact on other employees who are covering for them. We can't hire anyone else. So they're opening that conversation about, well, is this working? Like, do we have the flexibility to do the 9-day fortnight where they're taking their child to psychology, or they're taking their child to whatever, the child's got a specialist. You just don't know. So I think having the conversation about, okay, well, what's happening here, because it's not a personal attack on you, it's the impact on the team and what that looks like, and also your health and well-being as well. Like, I get kids are sick, I've got kids too, but you know, what does that look like? Are they trying to work part? I've got some where they basically work part-time, but they get that. So they're not getting paid, but actually working part-time. And I'm like, well, why don't you just say you're part-time? Like, we can talk about that. But they won't open the conversation because they're worried that they'll lose their job. So opening that up and saying, okay, what's happening here? What can we do?
And it could be a temporary thing.
Yeah.
You know, it might not be a long-term thing. There might be
You might not be able to do anything. You might just say, it's a full-time role, we need you here full-time, blah, blah, blah. I don't know, but that's sort of the conversation you need to have. Yeah.
What about the additional leave now that you didn't mention the DV leave?
Oh, domestic and family violence. Yeah, so there's new legislation coming to play with, if you've got more than 15 employees, it's already in play, that they're entitled to 10 days paid domestic and family violence leave, and for businesses with less than 15, it's from August that it'll be in play. So essentially, if you have an employee that's been subjected to family and domestic violence, they are entitled to take paid leave now to, for example, they might need to move house, they might need to attend court, they might need to seek medical attention, whatever the reason is. They're entitled to say, I need to take family and domestic violence leave. Now, one of the really important things is you cannot put on their pay slip family and domestic violence leave. And the reason for that is, for example, the partner might get their pay slips and they see that that's what they've done. That could cause a whole lot of problems. So you just need to pay them as ordinary time, and you need to have another way of recording that within your system. Now, the leave doesn't accrue from year to year. It's basically a use it or lose it sort of scenario, but you can request evidence that so it could be a police report, could be court documentation, it could be a stat dec. I had a client, one of my clients, they've already had it, and it wasn't actually, it was the brother of the sister, so it was his sister who was the victim of the violence, and he needed to take her to court. So that person was entitled to be paid for the day.
Because it was like carers.
He was supporting the person who was, it was a fan.
People supporting DV.
Yes, so he was the brother of the victim, and he had to take her to court. And so we did a big look into it, and he was entitled to that day. So look, realistically, I know a lot of employers were like, oh my God, this is crazy. Yes, there'll be somebody that will have used the system at some time, but you definitely need a policy, but you also need to be, I suppose, if somebody owns it, is open about what they're going through and experiencing in that, like generally speaking, most of the employers I deal with would have supported the person anyway. So, and yeah.
So that doesn't come off annual leave,
No.
carers leave, anything,
No,
it's something we just pay extra.
It's a bit like your compassionate leave. You don't accrue it. You only use it when there's an incident, right? So they get 2 days per occasion. It's there if they need it, but it doesn't accrue. You don't have to keep it you need to keep a record of it. Maybe if somebody's experiencing it in that year, so maybe keep a separate file of, well, they can only have 10. So, if they start taking it, and next thing you know, they've taken 15, then you can stop it. Like they're limited to 10 in a 12-month period.
Which is why the policy is really important, because it would set it out. You can refer them to the policy, and it's really clear.
Yeah, which is probably a good reason to have EAP, employee assistance programs, within your businesses as well, so that you can actually offer that to those individual employees if they're experiencing those things at that particular time, because it removes you from you want to help, but you also don't want to overstep the boundaries as well as an employer. So it's actually a really good way to refer your employees who are going through difficult times to an employee assistance program. Coutts do it, and it works really well. We have staff that,
And everybody has their own, whether it's domestic violence, whether it's divorce, whether it's family issues, grief, So providing that service is part of the work health and safety obligations in terms of, the positive duty, the ability to provide a safe work environment, like supporting, as much as and I'm definitely, just get on with it. But the problem is that mental health is really high, and so you're better off to support your employees in that space than not, because it will have a direct impact on your business.
It's having an impact on your business anyway, because they're taking the lead off, right?
So you got to weigh those things up.
And there's organisations that you can have them provide the service, and you only pay for it when they need it.
Yeah. And it's anonymous, so you just get a bill from EAP. You don't know someone's used EAP, but you don't know who, and you just get the invoice when So it's quite a good service. Particularly, it's hard because there are some boundaries about you can't ask people direct things, but you want to support them and provide them, particularly if they're a very valuable employee and they're just going through a stage, right? It might just be a short period of time. Everybody goes through it, and so it's a really good way to sort of outsource it a little bit. Yeah.
So
Any other questions?
Any other questions? Okay. Thank you all for coming.
Yeah, I appreciate it.
Thanks.